Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I am here, right here, on this station every Sunday from 8 to 9 a.m. to bring you, the landowner, the valuable information that you need regarding natural gas development here in Pennsylvania. And in case you have forgotten, in case you need reminded, or in case you don't even need reminded, I just like to say it anyway, I represent Pennsylvania landowners, oil and gas right owners. I do not, have not, and will not represent gas or pipeline companies. I represent the Pennsylvania landowner. For such items as oil and gas lease negotiations, reviews, consultations, pipeline agreements, waterline agreements, negotiations, reviews, unitization issues, been working more and more with issues regarding have you been properly unitized? Were you unitized in good faith? Is there any issue that we see relative to the unitization of your property? Gas lease amendments and modifications, extensions of your existing leases. Because of the lack of drilling in the low gas price market, a lot of opportunities have come about for Pennsylvania landowners. We need to seize those opportunities. Take advantage of the opportunities. Rarely do we get a second bite of the apple, and when we do, we want to take a big old juicy bite of that apple. Surface use agreements. In sum, any agreement related to oil and natural gas development whatsoever, meter site, compressor, on and on and on. Also, doing more with real estate transactions in oil and gas areas. Please be careful. Too many people, it's amazing to me, but I talk to too many people who engaged in a real estate transaction that either thought they were keeping the oil and gas rights, thought they were receiving the oil and gas rights, and lo and behold, the transaction didn't go like they thought it was supposed to go. If you're engaged in a real estate transaction in the oil and gas areas, please get an attorney who's familiar with these issues. Whether it's me, that would be great, or somebody else. Please make sure you're getting an attorney who is familiar with these issues. Too many mistakes are being made, and they can be unbelievably costly. So we have to make sure that when you engage in these transactions, that they occur the way that you want and intend them to occur. Also, buying and selling oil and gas rights. In the down market, there's a lot of what I consider predators out there looking to buy gas rights, oil and gas rights very cheaply. I just had a landowner who entered into an agreement to sell his gas rights, and he contacts me after he enters into the agreement, and all I can do is think, why didn't you call me before you signed the agreement of sale to sell these oil and gas rights? Please call me, call somebody before you sign the document. Too many times people will sign a document and then call to ask questions about it. Don't do that. Don't do that. Before you put pen to paper, call. You can always call our office, 570-307-0702, 570-307-0702. Don't care where you are located. I'm very confident we can help you. You can call me anytime. I have clients we've had clients in Greene County, Armstrong, Allegheny, Westmoreland, Butler, Beaver, Washington, on and on and on in the southwestern corner, all across Potter, Tioga, Lycoming, Bradford, Susquehanna, Wayne, on and on and on, Wyoming, Sullivan, all over where oil and gas is produced or is expected to be produced. So please don't let distance concern you. Make the call and then decide. Again, you can call us 570-307-0702. And while I guess I'm in the commercial phase, I just want to remind everybody, go to pagasleaseattorney.com. Go to pipelineattorney.com. Go there to get information. If you want to learn, you want to get more information, check out the websites. Our websites are pagasleaseattorney.com and pipelineattorney.com. I'm very confident that there'll be a great learning resource for you. Whether you're looking for representation, want to learn more about me, Attorney Doug Clark, you want to learn more about the Clark Law Firm, or you want to learn more about oil and gas contracts, issues, development issues, check out pagasleaseattorney.com, check out pipelineattorney.com. All right, I'm going to transition now. We're going to move into the show. Reminder, you're listening to All Things Marcellus with me, Attorney Doug Clark. I'm right here on this station every Sunday from 8 to 9 a.m., and I've been doing the show since 2010. So we're at our 6-year anniversary of All Things Marcellus. So make sure, check us out every Sunday. Check me out every Sunday, 8 to 9 a.m. right here on this station. Okay, let's dive into it here. What I'm going to talk about first is going to be roadway agreements, but just not that simple. I love this topic. I'm telling you, I love this topic. Also, if I have time, and I'm concerned I may not, I'm going to throw this. I've been dying for weeks. It's been on my list here to talk about arbitration provisions. Arbitration provisions. Please, if you're going to sign a document with an arbitration provision, be very, very careful. I have now a policy as a general rule that we avoid arbitration provisions as much as we possibly can. If you can avoid an arbitration provision, as a general rule, not specific advice for anyone, avoid the arbitration provision. Companies are using these provisions to, what some people think is to steal, take in small amounts from large groups of people because it costs too much money to go through the arbitration process, and because it is extremely difficult, if not now impossible, to proceed through a class as a class action in arbitration under these leases, under the pipeline contracts, which means if you can't group together, you have to go individually. Very, very expensive. So if you're losing $1,000 a year and you say, hey, I think I have an outstanding claim, but it's only for $1,000 each year, well, you say, it's not cost effective to bring that claim. Well, let's say hypothetically that you're a company, and again, this is hypothetical, but say that you're able to take $1,000 maybe in deductions or whatever the case may be, but you're taking $1,000 and each person is having this $1,000 per year taken, believes they have a good claim against the company. Maybe they do, maybe they don't. But let's assume for this hypothetical that they do. So you get 1,000 people where a company is doing something or interpreting a contract a certain way that allows them to withhold $1,000 for whatever reason. Let's say by way of deductions, and so from royalty payments. So if you have 1,000 people and there's $1,000 at stake for each person, well, 1,000 times 1,000 is 1 million. So as a company, you would be keeping $1 million. But as a landowner, if you only have $1,000 being taken and you think you have an outstanding claim and there's 1,000 of you, but you can't group together, well, what's going to happen? Well, the reality is no one's going to bring an action. No one's going to sue the company. Let's bump it up. Let's say now we have, instead of 1,000 people at $1,000, let's say we have 10,000 people. And instead of it being $1,000, let's say it's $5,000. Well, once again, at $5,000 in damages, if you're a landowner and you think, hey, I got a great case against the company, but my claim is only about we'll say $5,000, and we'll say per year. So to bring an action against the company, it's not going to make sense. It's going to cost too much. The fees, the expenses, the time, it's going to cost too much. So hardly anyone, if anyone, is ever going to bring that action. Well, if you have 10,000 people and they're in that same position, and we'll say hypothetically it's royalties being deducted from, and say each person in the hypothetical has exactly $5,000 per year being taken, well, that's a total of $50 million combined. $50 million. So you take 10,000 people, then you take $5,000 from each person and they have a claim. Well, now that's $50 million a year, but that's combined. But individually, they each only have $5,000 as a claim, so they're not going to bring it. Well, arbitration provisions are used by companies. Pay attention, please. Very important. Arbitration provisions are used by companies to stop class actions, to stop group actions. So you take some from a large group of people, well, they're not going to come after you under arbitration, and they can't combine together. So what does that mean? Well, some people may say that's a license to steal. I'm just giving you some hypotheticals. The problem is, the defense is, we got to get rid of these arbitration provisions. So in that scenario where you have a company who is taking in, and you have a good claim, let's just, this is a good claim. Well, if you did not have an arbitration provision, then you can proceed as a class. Now, the company may have a little bit more concern about withholding money or withholding funds, because now they haven't divided and conquered the landowner, because now the landowners can group together as a class with enough resources and enough at stake to take on the company. And the evolution of case law through the federal courts has made these class actions as an arbitration extremely difficult and possibly impossible to pursue. And look, the companies are smart. They know this. Load up the arbitration provisions. And if you have landowners who may have good, viable, strong claims, but for only a little bit of money, or even $5,000, which is not a little bit of money, but if that's $5,000 per year, it's not going to be something that that landowner is going to pursue against the company. Now, think about this too. Remember this. I'm going to leave you with this, and we're going to move on and talk about these roadways, which, again, are going to be, I think you're going to find extremely interesting. And it spills over to a lot of other different areas with lease interpretation and third-party rights. But anyway, let me get back. Sorry about that. So with this, if you have the company and they're taking, well, you think you have a very good claim for $5,000 a year, and we say, hey, there's 10,000 people that are in that same position. That's $50 million as a group claim. And remember, my hypothetical, I said that this is occurring every year. So we have $50 million per year. Then we go ahead, let's say this over a course of 10 years. Well, 50 million times 10 is 500 million, also known as $500 million. Then we go out, put another 10 years. Now we're at $1 billion. But it's $1 billion spread out over 10,000 people over 20 years. So an incredible deterrent for any individual to bring an action. But if you had a class action ability, then you could take on the company in a much stronger position. How does the company avoid this? Load up these agreements with arbitration provisions and defend against class actions. And class actions, the idea of class actions is to prevent a company or a person, but usually company, from taking small amounts from large groups of people. Taking small amounts from large groups of people. And here's a big news flash. Why does the company want arbitration? Shocking, not for you, for them to stop or deter class actions and put themselves in a much better position. Everyone out there, fight, in my opinion, fight to avoid arbitration clauses in your lease, in your pipeline agreement, or any other agreement. Fight to avoid it, because the companies are using those to deter and stop class actions, which I deal with this all the time, where I have landowners have great claims, but it's just not cost effective to bring the claims, and they have arbitration provisions, which essentially kills any chance for a class action. All right, you're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me right here on this station every week from 8 to 9 a.m. I'm going to talk about roadways and much, much more after this very important break. Stay tuned. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Again, you can join me right here every Sunday from 8 to 9 a.m. Okay, I'm going to talk about, and I say this often, I'm going to talk about roadways now, but this goes so much further than roadways. The same principle could apply to pipelines and at times even well pads themselves. And I'll explain all of this. So, okay, I had two different clients, two different landowners call me from two different areas of the state who were proposed a roadway, or a roadway was proposed on their property. Two different landowners, two different areas of the state, two different companies, but same type of issues. Now I'm going to focus on one, and what we're going to do, we'll play this out as a hypothetical. We'll play this out. This will be a hypothetical situation. So, okay, hypothetical landowner gives me a call and says, hey, there's this company who wants to put a roadway to a well site on my neighbor's property, and they want to put that roadway right through my property. And I'm not too excited about this roadway. Well, let me tell you, I'm very glad that the hypothetical landowner gave me a call, because I got all kinds of information that I'm going to give to this person that's going to be very valuable and very helpful to them. And in fact, may lead to no roadway or significantly changing this whole situation. So, okay, so landowner says, well, yeah, I don't want this roadway, and there's a lot of different reasons, but one is it's going to go right through the center of my property. Also, in this hypothetical, and say one of the, two hypothetical landowners, and we'll say one of them says, not only is the roadway going to go through the center of my property, but the company says that due to wetlands, and any listener out there who knows, if they have proposed surface activity on their property, that the company says wetlands, because of wetlands, we can't put this pad, road, pipeline, whatever, in an area that would be far less intrusive to you as the landowner. No, because of wetlands, we have to put this pipeline, roadway, or well pad in an area that you don't want the pipeline, roadway, or well pad. So in this case, company says, well, there's all these wetlands, so the only place that we can construct this roadway is right through the center of your property and within, say, 50 feet of your house. You know what, let's be nice. Let's say 100 feet. Let's say 100 feet, and I assure you, it's being nice. So we're going to put a roadway 100 feet from your property. Where's that roadway going to go? Well, it's going right from where your property accesses a state or township road, right through the center of your property, out the back end of your property to a neighboring property where there's going to be a well pad. Now, something elementary, but I just want to say, remember, well pads are the bigger area, the big rectangle square area where all the operations occur on the actual well pad or well site. On that pad or site is where the wells are going to be drilled from. And you'll see that very often companies permit 6 wells for this particular well pad, but sometimes they permit 10. Sometimes they permit more than 10. So there's absolutely been a trend to what's being called super pads, where the company is going to drill 10, 15, maybe even more wells from the same pad. Well, most likely, if they're going to be drilling all these wells from this super pad, you're not going to be getting royalties from all the different wells that are being drilled from the pad. Very, very important thing to remember for later on. So anyway, let me back up though. So the company says, we want to put this roadway right through the middle of your property. Yeah, it's going, would be nice, say 100 feet from your house. And because of wetlands, we need to put it there. Landowner says, well, I don't want it. I don't want it. Company says, well, listen, we're going to drill 10 wells. We're going to drill 15 wells, whatever it is. You're going to get a bunch of royalties from this. It's going to be great for you. Well, yeah, multiple things. One is, it's not going to be great for you to have a roadway across your property for the next 80, 50, 80, or 100 years. And the more wells that are going to be drilled off of the pad that this roadway goes to, the longer the roadway is going to be there. That roadway will remain until the last well is done producing from that pad. And honestly, I truly believe that very easily could be 100 years. I totally believe that could be the case. I also believe that at minimum, we're going to talk probably 50 years. That's my opinion. And if you disagree, or if you think a company says, oh, you're nuts, this guy's nuts, okay, fine. Let's start putting time limits in these roadway agreements. Let's say, yeah, you can have this roadway, but no more than 50 years. And see what happens. See what happens. Oh, yeah, it's not going to be that long, 20, 30 years. Okay, fine then. You say 20 years, let's make it 30. You say 30, let's make it 40. You say we don't know, let's make it 50. And see what happens. Well, I think you're going to find that companies are not going to agree to any restrictions on how long these roadways can be on the property, because they know that it could be 50, 80, 100 or more years. That's my opinion, and I think when you ask the questions and you try to put limitations on the length of time the roadway can be there, I think you'll start getting a little more confidence in my opinion that perhaps I am correct, and I really believe it. And I've asked those questions, so I have a little bit of experience on that. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm right here on this station every Sunday, 8 to 9 a.m., and make sure to tune in. So, okay, now we have our hypothetical landowner who is approached for this roadway right through the center of their property, divides it right down the middle. And then also it's going 100 feet from their house, but we don't need it 100 feet from the house. And we don't even need it to divide the property in the middle. It just can be in an area that you don't like it. Remember, roadways are going to be there for your lifetimes, and I think probably even your child's lifetime. So this is a major endeavor. You need to be extremely careful. One of my big issues that I see out there all the time is people don't realize the impact, the potential tax consequences, the liability issues that surround these roadways. People are making terrible decisions because, as always, it's because of a lack of information. So we need to get that information out there. So please listen closely. This is all true. I'm not making anything up. I deal with roadways all the time. Have dealt with roadways for years. They are tricky, and people aren't appreciating how tricky they can be. So the hypothetical landowner calls me and say, well, I'm sick. I got this roadway. I don't want it. Oh, this is terrible. Can you just look over the agreement? And I say, well, geez, I'm so glad you called me, because I don't believe that if you don't want this roadway, I would say with extremely high confidence, that roadway is never going to be there. It's never going to be there. And I can also tell you with high confidence that it's not going to, in this hypothetical case, in pretty much all cases, but not specific advice, I can tell you that it's not, I can't imagine it ever impacting future royalties or production. Companies' number one weapon that they always want to use to get you to sign things: money, 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 or promise of future money. Money. Promise of future money. Well, we need to do this pipeline for royalties in the future. That's where the big money is. We need to get this roadway in. We want to drill. We want to get this roadway in. Money, money, money. Future royalties, future royalties. Don't fall victim to the money trap. Become educated and informed. So landowner says, wow, this roadway is going to go through the center of my property. In this situation, it's going to immensely devalue my property. Whether you have a house on it or not, it's going to devalue your property. Roadways devalue properties. Roadway, buy a house, devalues the property. Who in the world wants to buy a house where you're going to have a gas company roadway and you're going to have water trucks potentially traveling right on that roadway by the hundreds? And if it's a super pad and they're going to drill 10 or 20 wells and they're going to truck that water to that pad site, every single time they drill, every time they frack, you're going to see an incredible amount of traffic. Also, dirt, dust, and all those other things. Roadways, as a general rule, are not something to be excited about as a landowner. So you must understand your roadway rights. Can you say no? Can you negotiate the roadway? Can you move the location of the roadway? In a lot of cases, the answer to all three of those questions is yes. Yes, you can. But you can't rely on the gas company or pipeline company landman to advise you of what your rights are to say no, to negotiate, or to move the roadway. You can't. You simply cannot. Why? Because the gas and pipeline company landmen work for the gas and pipeline companies, not you, the land owner. They work for the other side. Their job is not to educate you on your rights to say no, on your rights to negotiate, or on your rights to move the pipeline, the roadway, the well pad. That's not their job. They work for the company, not you, the landowner. So you must understand your rights. And thankfully, this hypothetical landowner called me, and I was able to give him some great news, hypothetically, saying, hey, look, you have multiple reasons that you can decline this roadway, and very significant reasons. And if you want the roadway, well, you can negotiate. You can say, I'm not going to take this $5 a foot, $10 a foot, $7 a foot. To me, that's a joke. You're not going to take that. You're not going to take $15,000 as a flat fee. You're not going to take that. You're going to negotiate, and if there's going to be a roadway that the company doesn't have the automatic authority to impose or to put on your property, well, you can negotiate, you can say no, and you're not going to take a lowball offer. And you're sure as heck not going to sign a roadway or a pipeline, but a roadway agreement that doesn't give you tax protection forever. Not just back taxes, future taxes. Your taxes go up because of the roadway. Well, you need that payment every year, not just once at the beginning, because the roadway can literally, no exaggeration by any stretch of the imagination, the roadway can actually cost you money because the money you're given is now gone after a few years, and you've now have an increased tax burden because of the roadway, and that tax burden will last as long as the roadway is there, which could be, again, 50, 80, 100 years. Very quickly, whatever money you've received will be long gone in increased taxes for the roadway. And not to mention that you've exposed yourself now to potential lawsuits and future liabilities for any accidents or anything that occurs on the roadway, because the roadway agreement or document you signed did not give you a proper or any indemnification language. And not to mention all of the negatives that go with the roadway on your property. And you take the hypothetical landowner with the roadway 100 feet from their house, that is a future nightmare, And not only is that a future nightmare, it may be a future nightmare that costs you money because you have to pay higher taxes every year because of the roadway. And if that roadway is assessed as a commercial at a commercial tax rate, the range right now in Pennsylvania is about $1,000 to $15,000, or I'm sorry, $1,500, $1,000 to $1,500 an acre, $1,000 to $1,500 an acre for a commercial tax rate. So if this roadway is, we'll say, 4 acres, each year that could be $4,000 or $6,000 $4,000 to $6,000 a year in additional taxes. Think about that. That can occur. $4,000 to $6,000 a year. So in 10 years, will be nice. Let's say it's $4,000. That's $40,000. 20 years, $80,000. 30 years, $120,000, and so on and so on and so on. You gotta protect yourself. You got to protect yourself. And people who sign these later on, when you say, "What the heck just happened? I got my tax bill." Here's what's gonna happen. Well, landowner, here's the company. Well, landowner, you signed this agreement. Yeah, we paid the back taxes. We paid your rollback clean and green taxes, but you're on your own from there. You signed the agreement. Those are words you never want to hear because that means it's bad for you. You signed the agreement, so deal with it. As always, I'm way over my time. Stay tuned. We're going way more. We're just scratching the surface here. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm right here with you every Sunday from 8 to 9 a.m. Make sure you join me each week. And if you miss any of today's show, you can go to pagasleaseattorney.com, pipelineattorney.com. We'll post today's show. It'll be up tomorrow, Monday morning, and you can check out hours and hours and hours of prior radio shows. Again, we just are hitting our sixth year anniversary of All Things Marcellus. Check out pagasleaseattorney.com. Check out pipelineattorney.com. Okay, jumping back into it now. Talking about roadways and how you need to make sure that you are getting someone who's going to assist you so you understand your rights. Landowners, big area right now. Landowners, in my opinion, and I think it would be anyone's or any reasonable person's opinion, are being taken advantage of and signing roadway agreements thinking that they don't have a choice. And I'll tell you this, if you're signing a roadway agreement, you have a choice. Now, you have a choice, and usually that choice is to simply decline. Worst case scenario, maybe a roadway can be installed under your lease, but there are many restrictions when that occurs. So when a company presents a road right-of-way agreement to you, you need to say, okay, I better get some information here, because I could maybe say no, I could negotiate a higher compensation for this, or I can also negotiate better language to protect myself. And even if you're in a position where the roadway would be allowed under your lease, if you're signing a roadway agreement, you can bet strongly and high, you can bet a large amount that you are giving the company more rights than they have under your gas lease. Same thing with pipeline right-of-way agreements. Same thing. You're signing a separate contract. That contract lives on its own. You're giving the rights that are in that contract, and those rights are going to be more powerful, more or broad. They're going to be larger, expansive than what the company has in your gas lease. And again, whether it's a pipeline agreement or a roadway agreement, by signing the separate document, by signing a separate roadway agreement, by signing a separate pipeline agreement, please listen closely to this. You are giving the company more rights than they have in your gas lease. And in most cases, you're giving them significantly more rights. I'm not talking about a little bit. I'm talking significantly more rights. And in many cases, and I think probably more than half, if not way more than half, you have simply the ability to say, no, I don't want to do this, or negotiate. Again, roadways, pipelines, we're focusing on roadways, but it's the same thing with pipelines. It is killing me to see people out there signing these agreements thinking, well, they can do it under the lease anyway. Please, if they're telling you they can do it under the lease, I'm going to say it. Call me. Let's find out if that's correct. 570-307-0702. 570-307-0702. My hypothetical landowner, roadway right down the center of their property. Couldn't be worse. You could take this property and say, where in the world would be the worst place to put a roadway? And every single person would draw a line in the same place. So landowners sick. They're sick over, oh my heavens, I'm going to have this roadway on my property and I don't want it. Well, and the company's saying, well, they have these rights and all these other things that pressure me, all this different stuff. Well, get some assistance, because it ends up, the reality is you can simply say no. You could absolutely say no. So a landowner who thinks, oh my heavens, losing sleep at night, saying, I'm going to have a roadway 100 feet from my house. This is terrible. It's going to be there forever. This is a family property. We love the scenic beauty. This has been in our family for generations. Or I bought this property. I wanted to build here. I wanted to retire here. I sure as heck don't want an ugly roadway that's going to have hundreds and maybe potentially thousands of massive water trucks traveling over and across this roadway. Do I want to do that? Why? Why would I want to do it? I don't. But apparently I have no choice. No, back up. Let's find out if you have a choice. Too many people are signing roadway agreements and pipeline agreements thinking they have no choice. when in reality, they have a lot of choices. They can say no, they can negotiate compensation, they can negotiate language, which you must do. But what you must do more than anything is find out what your rights are to say yes or no, especially no. And you cannot rely on the gas and pipeline company landman to explain your legal rights, your contractual rights, legal rights to say no or to negotiate. You can't rely on them. One, they're not attorneys. This is legal advice. They're not attorneys. Number two, and most importantly, again, they work for the gas and pipeline companies, not you. Stop relying on advice for somebody who works for the other side. Please stop doing it. Call me, call somebody, but call somebody working for you. So this gentleman is not going to get a roadway. This hypothetical case, there's not going to be a roadway there. Or it's going to be there, but it's not going to be in that location. Or if it's going to be anywhere, it's going to be for I think I have to say the word heck, a heck of a lot more money than what's being offered. And the person's never going to be exposed to any type of liability issues. Roadway, roadway, potential accidents, lawsuits. Who gets sued? Well, I don't care if you did anything or not. Lawyers are going to sue everyone they can. And you now can be even a bigger target if you're getting royalties or you're in gas production areas. You have a target now on your back more than ever. But not that you didn't need to protect yourself before, but more than ever, you cannot let yourself be exposed to liability. Lawsuits cost money. Even if you didn't do anything, lawsuit filed against you, you have to defend it. You have to hire a lawyer. You need to stop that. You don't have to expose yourself to that. But if you don't negotiate, you don't do work from your side, it's most likely you have an agreement that doesn't protect you at all. So you sign this agreement and boy, maybe there is never a lawsuit, but boy, if there is, that is not going to be a good situation for you as a landowner. And another really bad situation, I'm not going to beat this up more right now, but taxes. I'm so tired of hearing, oh, yeah, we'll take care of any clean and green impact. Listen, guys, I don't care what it is. Clean and green impact. If you have property taken out of clean and green and you have higher taxes, yes, and this is a big if because a lot of these roadway agreements don't cover this, if you have language that has tax relief, if you have that, almost guaranteed, what it says is that the company will pay rollback penalties or back taxes for property removed from clean and green. They'll pay that, but they will not pay any additional tax consequences on your behalf. They will not pay for future tax increases. They will not pay for future tax increases unless you negotiate that in there. I can't tell you how many people call me and say, oh, well, we don't have to worry about taxes. The landman said it's in there. No. You got to look at the document. Yeah, you may have coverage for the last 7 years in back taxes, but in the future, if you have 50 acres and 5 is taken out of clean and green, that 5 acres will be taxed at least the fair market value rate as opposed to the lower clean and green rate, or potentially a commercial rate at between up to $1,000 to $1,500 per acre each and every year. So don't fall for this. Oh, I'm covered in taxes. You may be covered in back taxes, but talk to the landowners now who are paying heightened taxes every single year because of a well pad or roadway or surface facility on their property. You have to protect yourself. And I look at these roadway agreements, the whole roadway agreement right here. No indemnification, no clean and green tax coverage, no future tax coverage. It's really, really bad. And people are signing it. And the sad part is most of these cases, you can say, no, I'm not going to sign. You could say, hey, well, if you think you can do it under the lease. But most you can say no, or in virtually all, you can negotiate. Remember again, if you're given a separate pipeline or roadway agreement, you are giving additional rights. Those rights are beyond, bigger, broader, more expansive than the rights contained in your gas lease. Be careful. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me right here every Sunday, 8 to 9 a.m. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm going to jump right into it. So, okay, I'm going to tie this all up. We're talking about roadways. Remember, a lot of these principles apply to pipelines as well. Most importantly, if you're presented with an agreement, get help. Whether me or somebody else, please get help. And do not rely on the company landman who works for the company. So, okay, in my hypothetical example, we have a roadway that's going to go right through the center of this landowner's property. To make matters worse, but please don't focus solely on this fact, it's going to go very close to that landowner's residence on the property. But either way, this is not something a reasonable landowner is going to want to have. It's going to incredibly, in this case, devalue that person's property. So your property could be sold at $300,000 with a house and the property before the roadway. Who wants to buy a $300,000 property with a roadway right down the middle? You got to remember, crossing the roadway could be an obstacle if you want to go from one side of the road to the other. Crossing it, that can be an issue. You got to be very careful about that. But also, who wants to buy a house looking out over this ugly roadway? And that's just the beginning. But you're going to in this case, there's going to be a major devaluation of this property. But let's not focus again even on that. There's a lot of things we could focus on. We're not even going to focus on that. Let's just look at the fact that you're going to have a roadway where you don't want a roadway. So, okay, we look at then, let's try to assess what your rights are. Let's assess what your leverage is. Let's assess how you want to handle this. And the first thing we're going to do is look at your gas lease. Does your gas lease allow this roadway? Well, most gas leases are going to allow roadways that are going to a well site where your wells are located. But, and I could say that for the next 5 minutes. But, these leases typically have restrictions, and a lot of times they are very hidden to a normal landowner. And shockingly, it's not something you would think and expect or typically ever see the landman explain or point out to you where the company restrictions are, because they want the roadway. They work for the company. Company wants the roadway. Do they want their agents, their landmen, to go out there and tell you, well, you really don't have to do this. You can simply say no because your lease has this language or that language. No, I've never heard of that happening. If that's happened, call me. I'm interested. 570-307-0702. But no, what happens is most landowners have this impression that they have no choice. And let's talk about this. When I say that most leases are going to allow a roadway or a pipeline, but allow a roadway to go across your property to a well pad that's going to have your wells, which you're going to get gas from, that's very limited. Remember, I talk about these super pads, and they don't have to be super pads. If the roadway is going to a well site where there are going to be wells, some of which are going to produce gas from your property and from a unit that you're a part of. But, again, insert 25 buts here. But, if that roadway is going to a well pad where wells are going to be drilled to other properties, to other units where you're not going to get royalties from, there is an extremely strong likelihood that there is no right to put that roadway on your property. So what does the company do? Well, if they can't do it under the lease, they hand you the old right-of-way agreement, a piece of paper. And why? Because if you sign that, you give the company, like I've said multiple times here today, significantly more rights, namely to put a roadway, in this case, where there's no right to a roadway. So if the roadway goes to a pad and that pad is going to have wells that are going to be drilled that you're not going to get royalties from, in most cases, you can simply say no. But the companies don't tell you that. Also, they'll talk to you about, oh, you're going to get royalties from these wells. Well, what about the other wells? And do I want to have a roadway that's going to go to other wells that I don't get any gas from and deal with all the truck traffic and all the noise and all the activity, and I don't get any benefit from it? Well, most people, the answer is probably going to be no, especially if I don't like where the roadway is going to be. I don't like the fact that I have no indemnification, that I have no tax protection. Clearly, why would any reasonable, rational person ever sign it? Well, they wouldn't, but they don't understand these things, and that's why we have to get you the information. And quickly, I've represented many, many landowners who've signed roadway agreements. So I'm not saying we don't sign roadway agreements. We sign the right roadway agreements. We sign fair ones. We protect you. We get you the most money we can. And when you don't want it and you can say no, we have you say no. So, okay, that's one way. One way. Now, another thing is, you may have, and what you got to watch out for is maybe the first well or two you may benefit from, but in the future, additional wells, which aren't even planned now, the access road couldn't be used for those wells unless you sign the agreement. Nobody's telling you that. I am, but nobody else. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So, okay, next. In this case, my hypothetically, landowner has a provision that says, before you put a roadway in, you have to get my mutual consent, my approval. Yes, it also says my approval can't be unreasonably withheld, but a roadway down the center of my property is maybe an unreasonable request. A roadway down the center of my property that's going to be 100 feet from my house is probably a real reasonable position to say, hey, I don't want it there. You're going to incredibly devalue my property for, potentially ever, 50 to 100 years, certainly in my lifetime. That's going to occur. So even, and this is a huge, even if the roadway was only for your wells, you still, if you have mutual consent on the location, can say no and be very reasonable. You have to look at your specific situation. But I'll tell you this, I've never seen a company who will put a roadway 100 feet from somebody's house right down the middle of their property over the landowner's objection. I haven't seen it, and I don't think I will. I haven't. But they're not telling you that. Why? Because they work for the company. Their job's to get you to sign. When the company comes to you with a separate roadway agreement, heads up. Flags up. Same thing with pipelines. That's a request to give them more rights. And I'm going to read one phrase from this roadway agreement, which does not have indemnification language. No protection from future liability. This agreement has no time frames. When's it need to be installed? How long can they wait to install? How wide can it be? There's nothing in here. Oh, by the way, it doesn't even say where it's going to be located. There's nothing in here. Oh, future taxes? You're on your own. Nothing in this document. It is terrible, and it will almost assuredly cost you money for something that you never even wanted. So listen to this phrase. So the roadway, how long is it going to be there? Well, the right-of-way herein granted is limited to use. Oh, that sounds good. We like limitations as landowners. In connection with the gas company's ongoing oil and gas exploration and production operations, and at such time as operations shall permanently cease or terminate on the landowner's property. Check this out. Here's the phrase. And other lands in the vicinity for which the grantee uses the right-of-way. Look, they're saying right to you, yes, we're going to be using this right-of-way, and we're going to use this roadway not only for wells that are going to be in your property, but other wells as well. And sometimes they daisy chain and connect these roads. So it could go across your property for the neighboring super pad, and then it could continue on from that pad to another super pad. So You could have 20 wells on one pad, will be nice, say 10 on another. Now your road that you didn't have to agree to, that you did not have to agree to, is going to be used to access 30 wells. 30 wells. All the truck traffic, all the rig traffic, all the worker traffic, all of that is going to go across the roadway on your property that you never even wanted, that you could have said no to. That you could have said no to. And by the way, you're getting no liability protection. If there's an accident, a lawsuit, you get sued, you have to defend it. By the way, if there are future taxes that are increased because of the roadway, if you're in clean and green, you're going to pay additional taxes for as long as that roadway is going to be there. This document offers you no protection. None. And on top of that, this document doesn't even give you back taxes protection. So the first letter you get from the assessor's office is to say, well, see, you got this roadway here. Well, what does that mean? Well, you owe us 7 years of back taxes, penalties, interest for 7 years for this area of the roadway. Here's the amount. Send us a check. Well, hey, company, where's these? You got to pay these taxes. Company says, well, it's not in your deal. You didn't sign it. Or you signed the agreement. It wasn't in there. You signed the agreement. So, okay, we have to get this information out there. We have to do better. You have to understand your rights. And again, we're talking about roadways, pipelines. Remember, this isn't individual advice for anybody, but dang sure general advice and specific advice to get specific help for you and your property. So, all right, I want to close this out and just say again to everybody, please understand, additional contracts, roadway agreements, pipeline agreements, surface site agreements, they give more rights than your gas lease. You have to understand your gas lease. You have to understand your ability to say no, to negotiate money, and the need to strengthen these agreements to protect you. If from nothing else, but there's a lot more, but if from nothing else, from increase in future taxes that you will have to bear potentially for the next 50 or 100 years. Then on top of that, no liability coverage, that you can be sued and at least have to pay for the defense of the lawsuit and potentially any judgment that would ever be found against you. You would be responsible for that as well. Elementary, we can't do this. You can't do this. In a lot of cases, you can just simply decline the offer. Simply decline the offer. It scares me how many people have roadways and pipelines and have agreed to roadways and pipelines that they never, ever would have agreed to if they knew their rights. Know your rights. Like I say, I do these reviews and consultations, usually 1 to 2 hours, explain all your rights, have you informed, and you can decide. And I'm telling you, time and time again, they are such a good value. People love it. People come out of these things so much more informed. I really encourage you, if you are given any contract, give us a call, 570-307-0702. I know, if nothing else, a review and consultation will be extremely, extremely valuable for you. I know it will. So, okay, we're against it here. I want to remind everybody 2 things. 1, stop signing bad agreements. Stop signing bad agreements. And number 2, remember, the landman works for the gas and pipeline companies, not you, the land owner. You've been listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Have a great week, everyone.